Welcome back to the Loud Little Ducky. Today we are going to finally go over the motion that the declaration that Gingras submitted that we went over in a previous video, which I'll link down below. This is the motion that goes with it, and he says that you need the motion, and I guess that's supposed to make his declaration even better and maybe less bullshitty. I don't think so, but in this motion, Gingras wildly speculates, wrongfully I might add, in this motion. And he makes these speculations just as he did in the Owens v. Eckerd matter without clear and convincing evidence. He has no proof. He is just saying shit out of his ass to a court that he has nothing to go off of. But that's what Gingras does, is speculate. He does not speak on anything with proof because he's not based in reality. But let's jump in and see what this is. So here is the paper responsive declaration to request for order. And he did this for a hearing date that was supposed to be on August 2nd, 2025, which has been moved to October 10th, 2025. And so he has other orders requested and does not consent to the order requested. So he does not consent to what Omar wants in this emergency hearing to have Gingras disqualified and to go over Gingras's motion that we're fixing to go over. So this was filed on October 10th, 2025 by David Gingras to the Honorable Judge Carolyn Gold in the Owens v. Maricini matter in the Superior Court for the State of California, County of San Francisco. This is a non-party/intervener David S. Gingras' response to Respondent Michael Maricini's ex parte motion for order shortening time. Because Omar wants this done before the hearing date on October 21st. Which I think this will get cleared up, probably Friday of this coming week. So it says, non-party/intervener David S. Gingras respectfully submits the following response to Respondent Michael Maricini ex parte motion for order shortening time. To summarize the issue, this matter involves a request by petitioner Laura Owens to renew a domestic violence restraining order against Mr. Maricini. That request is currently set for a hearing on October 21st, 2025. Yeah. So why can't the whole thing about you being dismissed off this case happen before then? If you're not going to represent her. But David is going to say that's not the problem. I have no problem with not being on the case. It's that Omar said that I didn't intend to represent Owens when I said I'm not representing Miss Owens. That's how Omar lied, is intended and not. That's the word we're fighting over because he's playing word games. In addition to Miss Owens' DVRO request renewal, there are 3 pending motions before this court, all currently set for the same date, October 21st, 2025. Mr. Maricini's motion to disqualify David Gingras, Mr. Maricini's motion to dismiss, non-party intervener David S. Gingras' motion to intervene, and motion to strike, motion for sanctions, etc. Yeah, those are things that we don't need to be dealing with on the 21st. Because on the 21st and 22nd, we should be hearing about the evidence in this DVRO renewal, not dealing with nonsense on the side. Mr. Maricini now moves ex parte for an order shortening time as to two of these motions, for David S. Gingras' motion to intervene and other requests and respondent's motion to disqualify David S. Gingras. Based on this request, Mr. Maricini wants the court to decide 2 out of the 3 issues before October 21st. Number 1, Mr. Maricini's motion to disqualify, and 2, non-party intervener David Gingras' motion to intervene, motion to strike, motion for sanctions, etc. To the extent this is the only ex parte relief sought, it is not opposed. Then why are we here? Why do you even need to write this? Once again, wasting the judge's time for all this hogwash that's happening. You could have stopped right there. And then all of this would have been moot. But no, you continue on. So, now he says, to the extent this is, oh, okay, we already read that. It's not opposed. It makes sense for this court to resolve collateral issues prior to the hearing the merits of the DVRO renewal request. But there is one important caveat. Mr. Maricini's motion to disqualify is not yet fully briefed, nor is the sanctions intervention motion fully briefed. Accordingly, neither of those issues are ripe for the court to decide. The motion to disqualify was originally noticed for hearing on October 10, 2025. This court subsequently changed the hearing date on that motion to October 21, 2025 to coincide with evidentiary hearing on Ms. Owen's renewal request. Based on the new hearing date, the opposition to the motion to disqualify is not yet due. The opposition is due October 8, 2025, and Mr. Maricini's reply, if any, is due October 14, 2025. Thus, the disqualification motion is not fully briefed. Can you not fully brief it before the court? I mean, things can be put in writing, but do you really need all that time? I'm not saying that it's not allowed, but if you're not opposing the motion, why can't that be done? Similarly, the motion to intervene, which was sought sanctions and other relief, is presently noticed for October 21st, 2025. Mr. Maricini's opposition to that motion was filed yesterday, September 30th, simultaneously with his current ex parte request. This means the reply to Maricini's opposition to the motion to intervene is not currently due until October 14th, 2025. You do not need till October 14th, 2025 to write up whatever gibberish you want to put in. And I'm sure Omar is busy, but he's the one requesting shortening time. So I'm sure with Omar requesting that, he is saying that I can get this opposition out before the 14th. To the extent Mr. Maricini wants the court to change the hearing dates and rule on the 2 competing motions before October 21st, there is no objection to that request, provided the court allows sufficient time for the parties to complete briefing the issues. This requires giving sufficient time for the undersigned to file a substantive brief opposing the motion to disqualify, which has not yet been filed but will be filed ASAP, as well as allowing Mr. Maricini time to file a reply. Sir, what else do you have to say that you haven't said in your declaration? You've talked about the phone calls. You have talked about the fact that you were, you're a witness, all that. What else is there for you to talk about? You've explained why you think you're right and everybody else is wrong. So why haven't you filed your opposition to the motion to disqualify? Why are you even opposing it when you're not going to be the attorney of record? So you say. Just keeps making more chaos about this nonsense. To be clear, the procedural posture of these matters is unfortunate. The undersigned contends that Mr. Maricini's motion to disqualify is moot for one simple reason, because the undersigned no longer represents he says Mr. Owens, but it should be Miss Owens, in this matter. Thus, whether the motion to disqualify is granted or denied, the outcome will be the same. The undersigned will participate in this matter only as a witness, but not as an advocate. Based on that simple fact, there is no need and no basis for this court to disqualify the undersigned from representing Miss Owens because the undersigned does not represent Miss Owens. That being the case, if this court wishes to deny motion to disqualify as moot, I could certainly do that now, which would save time. Just say to the court, I am not representing her now, and I will not be representing her at any point during this case. How hard is that to put? Or just to say to the court on the 10th? And then it's on the record. But no, you want to continue the circus. Nevertheless, that would not resolve the separate issue of whether Mr. Serrato should be sanctioned for filing a groundless pleading, for lying to the court, and for bringing a motion which he knew contained false statements solely for the purpose of harassment. Nobody fucking harassed you, David. Because those issues are necessarily intertwined with the merits of lack thereof, Mr. Maricini's disqualification motion, even though the disqualification issue is moot, the court still needs to receive complete briefing before resolving both pending motions. For those reasons, to the extent Mr. Maricini prefers to have the court resolve his motion to disqualify and the motion to intervene sanctions prior to October 21st, that request is unopposed. At the same time, this is hardly an emergency, and as another judge once wisely stated, filing an ex parte motion is the forensic equivalency of standing in a crowded theater and shouting fire. There had better be fire. Okay. Here, there is no fire. While it certainly makes sense for the court to resolve the sanctions and disqualifications motions promptly, there is no urgent reason to do so before the matters have been fully briefed. Omar just wants it done before the 21st when the DVRO evidentiary hearings happen. That's what he wants. But you want to play games instead of just doing what you should be doing. And then he attached his proof of service and signed under the penalty of perjury of the laws of state of Arizona and everything like that. So, at the time of service, I was over 18 years of age, not a party to this action. My business address is in Arizona, so that's why he's declaring under Arizona's penalty of perjury. Then he served Laura Owens with it and Omar with it. All right. Then we have the motion to intervene, motion to strike, motion for sanctions, and disciplinary referral. We've read the declaration that it goes with this, but this is the motion now that he says needs to be fully briefed. So, same judge, Honorable Carolyn Gold in Owens v. Maricini. Dear Diary, to respondent and his attorney. So to Maricini and the tilted lawyer. Please take notice that on October 21st, 2025, at 8:30 a.m. or as soon thereafter as a matter may be heard in Department 405A in the above entitled court located at the address Intervenor David S. Gingras, Intervenor or Gingras, will and hereby does move for an order imposing sanctions and relief on Respondent's Counsel Omar Serrato, Mr. Serrato, on the following grounds. This motion is brought pursuant to California Code of Civil Procedure 128.5 and is based on this notice, the attached memorandum of points and authorities, and such other papers, pleadings, and arguments as this court may allow. Intervenor seeks the following relief against Mr. Serrato. Number 1, an order imposing sanctions and fees on Mr. Serrato based on his making knowingly false statements to the court and for pursuing bad faith tactics that were frivolous and solely intended to harass in violation of CCP 128.5. I don't see where you think he lied and harassed you in regards to this case. And you cannot say that you have not harassed him back if you're saying talking about them in YouTube videos is harassment, which it's not. But let's see what else you have to say. 2, an order striking the motion disqualified filed by Mr. Serrato on August 25th, 2025, pursuant to CRC Rule 3.1322. 3, an order finding Mr. Serrato's conduct in this matter has violated the following rules of professional conduct. Rule 3.1A1, prohibiting a lawyer from taking any position in litigation without probable cause and for the purpose of harassing or maliciously injuring any person. Rule 3.3A1, prohibiting false statements to the tribunal, which none were made. Rule 4.1A, prohibiting false statement made to third parties. That never happened. And Rule 8.4C, prohibiting conduct involving dishonesty, fraud, deceit, or reckless or intentional misrepresentation. That was not done either. So I don't know where your proof is for this shit, because Omar hasn't done any of those things. 4, an order referring Mr. Serrato to the State Bar of California for investigation and discipline as appropriate. Just because you are under investigation and possibly being disciplined because there was an order referring you to the State Bar doesn't mean that anybody that goes against Laura should have to face the same consequences when they did not behave in the manner that you did. 5, any such further relief as the court deems proper. I don't think the court is going to deem anything proper. Memorandum of Points and Authorities. The introduction. In this motion to disqualify, filed August 25th, 2025, Respondent's Counsel Omar Serrato lied to this court. Specifically, in his motion, Mr. Serrato falsely avowed that 1, undersigned counsel continues to represent petitioner Laura Owens, Miss Owens, in this case. Where is that? Where did he say that he is continuing? At 3, 1 through 12. Okay. Okay. 2, that the undersigned counsel has a current personal conflict of interest that materially limits his ability to represent petitioner, which he does. And 3, that allowing Mr. Gingras to continue as counsel will prejudice respondents' rights and undermine the integrity of these proceedings. This is not him saying that you are continuing as counsel for her. He states that you said, verbally and writtenly, that you weren't. But if the court doesn't disqualify you, and you decide to come back and the court allows you to continue as counsel for Owens, that it will undermine respondents' rights and the integrity of these proceedings. He's not saying that you are continuing. He is saying if the court allows Gingras to continue as counsel. I know that comprehension might not be your strong suit, especially when you're knocking back bottles, but that's what that means. It does not mean that you are continuing to represent her. Mr. Serrato's representations are all lies. That's a bold statement and a lie right there. His statements are knowingly false. Mr. Serrato knew his statements were false at the time they were made for one simple reason. Days before this motion was filed, he was told repeatedly, both by phone and writing, that undersigned counsel no longer represented Miss Owens in this matter. The details of this issue explained in the declaration of counsel submitted herewith, which we've read already. Why on earth would any lawyers lie so blatantly to the court under these circumstances? There appears to be two primary reasons. First, Mr. Serrato has some sort of bizarre personal obsession with and hatred for the undersigned. No. Indeed, over the last 12 plus months, Mr. Serrato has posted multiple videos on YouTube falsely smearing, defaming, and attacking undersigned counsel. One such video contains an image that depicts Mr. Serrato physically assaulting/choking undersigned counsel with a caption that arrogantly and menacingly boasts Gingras doesn't want the smoke. Available at, there's the link, and then there's the picture of the thumbnail. Notice this was 11 months ago when this is filed. This is from 11 months ago. And Omar has not been representing Maricini or anybody in this case 11 months ago. And notice that it says doesn't want the smoke, because that'll be very important when we get to the next one. Mr. Serrato also made similar threatening statements, publicly disparaging and attacking Miss Owens in the context of discussing her actions in this case. In those public comments, Mr. Serrato again used the same gang violence inspired threat to Miss Owens, accusing her of fraud in this case, and suggests that she wants all the smoke. And then he's got a 1, and he's like, here's the YouTube, wants all the smoke. If the court is not familiar with the term, and hopefully it is not, asking a person if they want smoke is used as a threat of physical violence, as confirmed by image of Mr. Serrato locking undersigned counsel in a chokehold. The term carries an implied reference to gun violence, i.e., gun smoke. You are being disingenuous here. Mr. I'm the so-called Conor McGregor of litigation, who is a boxer. So Omar put y'all on put your faces on boxing people, and said he doesn't want the smoke. Or or Owens wants all the smoke. She just wants everything that's going, like, that is going towards her. She just wants all of it because she's not changing her behavior. She wants all the smoke. Because if she didn't, she wouldn't be continuing on her saga. It has nothing to do with physical violence, and you are being so disingenuous with the court. You know that is not what this means. So you're lying to yourself as well. An Urban Dictionary Really? That is not an appropriate source for the court of law unless you're talking about other things. Like maybe get Merriam's Dictionary or dictionary.com. But Urban Dictionary, where people can just put things in there and make them up. Because if I looked up my name in Urban Dictionary, do you know how many foul things are said about a person's name? Look up David in Urban Dictionary and see what it says. In any context, Mr. Serrato's threatening words and conduct would be inappropriate. In context of this DVRO case, it is inexcusable in the extreme. He didn't post that about this case, so that's one. Um, okay. This case involves a domestic violence restraining order. An order Michael Maricini initially stipulated to. The court previously found Mr. Maricini violated that order, resulting in a 5-year extension. Shortly before the extended order was to expire, Mr. Maricini violated again multiple times by releasing 25,000 pages of private text messages. Where are these 25,000 pages of text messages? Because I would like to see the 25,000 pages of text messages that somebody has apparently. Text message he exchanged with Miss Owens, and by traveling to Arizona and coming within 300 feet of Miss Owens, despite clear and unequivocal warnings such as interstate travel constituted a serious federal crime. I hope the court straight up says this is so disingenuous and it's a bullshit argument, and why are you bringing it to this court? All right. As a victim of this unlawful and criminal conduct, Miss Owens has come to this court asking for help a third time. In a clear attempt to silence and intimidate her, Mr. Maricini's counsel, Mr. Serrato, responded by posting videos on YouTube threatening Miss Owens and her now former counsel with physical violence. No, the fuck he didn't. No, he didn't. Nowhere in his videos does he threaten anybody. Let's go take a look at your videos, David. With your guns and firearms in them. Compounding that misconduct, Mr. Serrato blatantly lied to this court about the status of the undersigned's counsel continuing to represent Ms. Owens, a statement he knew as false at the time it was made. Would you like him to have perjury charges too? Even though that's not what he said? He didn't say it in that context. He then puts those lies into a pleading which he knew would be transformed into multiple YouTube videos. No, by his friends, resulting in Mr. Serrato's attacks being placed on the internet permanently. Nobody has said anything threatening to you or your client on the YouTubes. Because if they had, you would have proof. And there isn't any. Nothing that I have watched or seen anybody cover in this case, has there ever been a threat to you or Miss Owens? In fact, there has been encouragement for you and Laura Owens to go seek help. Go to rehab, go to therapy, whatever you need to do. Do those things to better yourselves, to get yourselves in a mentally better place. But there has been no threats. This conduct by Mr. Serrato should not make this court angry. It should make the court furious. This leads to the second apparent reason for Mr. Serrato's dishonesty. Although he is a licensed attorney, Mr. Serrato's primary focus appears to be making money from his YouTube channel where he refers to himself as the Tilted Lawyer. See, and he's linking his YouTube page. As this court may or may not be aware, creating and posting content on YouTube can be extremely lucrative. But there is a problem. Creating content is hard. No, it is not hard. It is time consuming. That's it. Because it requires new material and often a daily basis, leading to an insatiable desire for new content at any cost. No, it doesn't. Because people can be ethical when they're doing things, even if it is for money. But Omar's primary focus in making money is not his YouTube channel. It is his practice where he has real clients. This is just a side thing that he does for fun. But sure. And he also never talks about his cases. He talks about other cases that are in the news. He talks about life advice. But he has never given any information about any of his clients. Nobody knows who his clients are. Nothing. Because he doesn't do that. David, if you were commenting on a case that you weren't involved in, that would be fine too. Also, to gain the most views and thus earn the most money, each new video needs to be eye-catching, scandalous, and provocative. I don't think many of my videos are provocative. And they just are what they are. I mean, sure, can you make them more eye-catching and put certain words in there to make them more interesting? That's called marketing. But there's a lot of people on YouTube, such as myself, that are not making money. Do we have dreams of making money? Of course. If you can make money just saying your opinion and speaking from your life experience, why not? We have the right to free speech in America. And as long as we're not out here telling lies or threatening people, we're fine. Which none of us have done. Gingras goes on to say, seeking social media, money, and stardom, Mr. Serrato chose to file an utterly groundless, frivolous, and needless motion as a way of creating new YouTube content. No, he didn't. He did it because that is what is right in the case. Of course, posting a video about his motion on his own channel would be too sleazy, even for Mr. Serrato. Well, what does that say about you, Gingras? That you're sleazy because you posted content, YouTube content, on your YouTube channel during a case, things about your client and the ongoing proceedings, like you're being a hypocrite here. Or the fact that you blog about it on your law firm's web page. And I get it's your law firm, you can do what you want. It's just very unprofessional. Instead, Mr. Serrato filed his pleadings and waited for his friends to make videos laughing about the scathing allegations contained in the motion. There were no scathing allegations. Like, there were things that people have already been saying since anybody found out that you ended up representing Owens at that hearing. And the things that we've continued to say in the Owens v. Eckerd case. But there are no scathing allegations. We're just talking about filings in a case. And whether it was Omar or some random lawyer, if we had the pleadings, we would report on them. As we do with everything. Because we're following this. Shortly after the motion to disqualify was filed, Mr. Serrato's friends created multiple videos reciting every false statement in Mr. Serrato's motion. Examples: the Court of Random Opinion, which is Lauren Knighty's channel. Till the lawyer files motion to disqualify Laura Owens' attorney, Gingras. Yeah, that doesn't seem anything but accurate, because that's what happened. And let's see, her description. Omar Serrato, tilted lawyer, has filed a motion to disqualify David Gingras. Serrato represents Mike Maricini as a serial fraud, ... Okay? Then there's myself that he put in this filing. Motion to disqualify Owens' lawyer, Gingras, in a DVRO renewal case. Yep, no lies spotted there. Nothing funny about what we're saying in those. That is what happened. Reporting facts. And so I say tilted lawyer motions to disqualify Owens' attorney, Gingras. My description: Laura Owens' lawyer, David Gingras, finds himself intertwined as a witness and trying to be an attorney at the same time in a DVRO renewal case. Yep. That's what it's seeming like, because even if you're not representing her now, you did at one point in this DVRO case. Even if it was for 5 seconds. You did. No lies. Then he wants to put echoes from my tabernacle. Motion to disqualify serial pregnancy fraud. Laura Owens, counsel David Gingras, DUI douche canoe. Okay. You have said you're a douche canoe in your own video, because why not just run with it? Who cares what people call you? And then the title says motion to disqualify David Gingras as a serial fraud. Laura Owens, California DVRO case heats up. The description: in this episode, we read the motion and filing by tilted lawyer Omar Serrato, representing Mike Maricini, against indicted serial pregnancy fraud Laura Owens, probably. None of what has been said is false or untrue. And none of us are saying that these statements are that Omar wrote are in fact true. We are just reading what is put in the filings, word for word. But with your wild speculation and horrible accusations to a court, let's talk about some facts. Okay? I have never talked to Omar Serrato. I have never met Omar Serrato. So there is no plans by me, probably not by others, to make videos laughing and put out scathing allegations and everything else. I and another content creator in this motion are non-monetized channels, which means we receive no money from YouTube. Then, my first video I ever did on this case, or Laura Owens at all, was on February 29th, 2024. Leap Day. Lauren Knighty's first video that she did on the case, where she gave her thoughts as a psych evaluator, I believe is what it says, was on January 8th, 2024. Omar's first video came May 24th, 2024. And his last video on this was July 11th, 2025, was his last ever video made in any regards to Laura Owens. And then we have Omar representing Mike Maricini in August of 2025. So Omar has posted no videos about this case, or Laura, or David Gingras, since July 11th, 2025. And Dave Neal, Megan Fox, Legal Vices, Law Talk with Mike, they covered these cases before Lauren, Omar, or myself got on these. We have receipts and evidence to back up what we say and where we're getting it from. There is no false, defaming, or harassment that has occurred in any of these videos. Mine and from what I've seen anybody has say. Nobody has ever in these videos contacted anybody in this case, or Laura Owens, I would say. Laura, none of us have contacted her and to harass her. There might be an email that somebody is responding to because Laura emailed first, but that would be it. We're not sending our videos to her. We're not tagging her in videos. Everyone covering this topic may have similar views if they're covering this case or if they're following it. That doesn't mean that all of us know each other or that we are all friends. It means that we agree and have the same view on one topic out of millions of topics. Because there are plenty of topics that we don't agree on. We simply are reading the filings or watching things that are involved in the judicial process, whether that is body cam footage, court hearings, videos put out by a person in a case. We give our opinions, we react to them, and share from our experience in our lives, from our points of view, because all of us come from different walks of life. We come from different states. We have different full-time jobs. All of us has something different where our experience and our thoughts and our opinions and our views developed from. But I have lied about nothing, to my knowledge. Neither has anyone in this video that I have mentioned either. You have no proof or evidence to even be making wild speculations or accusing people of things. Definitely no clear and convincing. And the fact that you brought us into a DVR renewal filing that we are not parties to, we are not witnesses to, we are simply reporting on a case. And you want to put us in a legal filing that has nothing to do with anything. Why not let this just be this? Be ethical, be professional, and knock your nonsense off. Because it's not needed. And if I have to put that in a declaration to a judge that calls out your behavior, I will. Let's move on. By bringing a groundless motion based on knowingly false statements made solely for the purpose of harassment and YouTube fame, Mr. Serrato violated California Code Civil Procedure 128.5a. As a result, the court should impose substantial financial sanctions to deter similar future conduct. This should include a financial penalty payable to the clerk of the court for Mr. Serrato's waste of this court's time and resources, and an award of fees, costs, and expenses incurred in bringing this motion. No, you should. Because all of this is unnecessary. You are bringing social media shit into a California DVRO renewal. This is not about Laura Owens. This is not about Mike Maricini. This is about you. Mr. Serrato's conduct also violated multiple rules of professional conduct. The violations include Rule 3.1A1, prohibiting a lawyer from taking any position in litigation without probable cause and for the purpose of harassing or maliciously injuring any person. Nobody has injured you. Nobody is harassing you. You seek people out. We're not the ones seeking you out. We might talk about you, but that's it. Rule 3.3A1, prohibiting false statements to the tribunal, which never happened. Rule 4.1A, prohibiting false statements made to third parties. Who has made false statements to third parties? Nobody. Nobody has told anybody anything. And somebody putting it in a filing with the court and third parties reading it does not mean that he is making false statements to third parties. And Rule 8.4C, prohibiting conduct involving dishonesty, fraud, deceit, or reckless and intentional misrepresentations, which none of this has happened. The facts clearly show Mr. Serrato intentionally violated each of those rules. No. There are no facts put forward by you that show any of this. Accordingly, in addition to other sanctions, this court may impose, it should also strike the motion to disqualify pursuant to CRC Rule 3.1322 and find Mr. Serrato took positions without probable cause and solely for the purposes of harassment, and that Mr. Serrato knew his statements were false at the time they were made. Nobody is harassing you. They're just trying to make it so you don't come in and try to fight Laura's battles for her. Based on those findings, the court should refer this matter to the State Bar of California for investigation and imposition of discipline, if appropriate. Summary of facts. Mr. Serrato's misconduct aside, the facts of this case are simple. In 2018, Ms. Owens obtained a domestic violence restraining order in this court against respondent Michael Maricini. As the docket reflects, Mr. Maricini stipulated to the entry of the original order, an order which Mr. Serrato now claims as obtained by fraud. Yeah, because he didn't do any of those things. Two years later, in 2020, Miss Owens accused Miss Maricini. No, it's not Mr. Owens and it's not Miss Maricini. It's Mr. Maricini of violating the original order. This resulted in the court renewing the order for 5 years. Yeah, but he didn't even violate it then because he never came into contact with Laura when it got renewed for 5 years. But you probably are going to act like you've never read up on the case. With an expiration date of July 10th, 2025. On July 9th, 2025, Ms. Owens filed a request to renew the order against Mr. Maricini based on two different events. First, Ms. Owens alleges that in mid-2024, Mr. Maricini released 2,500 pages of private text messages exchanged between the parties in 2016 to 2018 while they were dating. It'd be really nice to see these 2,500 pages and where they've been. This fact alone, or standing alone, would be sufficient to find a violation of the DVRO. See in remarriage of case. Finding wife properly alleged abuse where her ex-husband accessed her private emails without consent and released content to third parties, and explaining husband's alleged conduct of viewing wife's private emails. We're going to continue to read this part and then I will say what I want to say. Learning her social schedule and communicating this information to third persons could constitute indirect and threatening contact, and thus abuse within the meaning of Section 6320, because the plain meaning of the phrase disturbing the peace of the other party in Section 6320 may be properly understood as conduct that destroys mental or emotional calm of the other party. Emphasis added. Well, first of all, if Mike Maricini released 2,500 pages of text messages, and all 2,500 pages are text messages, okay, between Owens and Maricini. That has to be true first. But if he did that, he released them from his phone, and they were between himself and an ex. And they were also parts of court filings, which are public. So, this thing where you're saying an ex husband accessed somebody's private emails and released the contents to third parties, if Mary Cheney had done that, maybe you'd have a different argument. But Mary Cheney did not go into her private emails or hack into her phone and just release phone call information and text messages with other people. He didn't go hack into her Google Calendar and post her whereabouts and what her schedule is and all this information to third parties. That didn't happen. So your case and this case are not similar. If Maricini had done that, then we could have a discussion. But that is not what happened in this case. Second, Ms. Owens alleges Mr. Maricini violated the DVRO proximity restriction by traveling to Arizona in June 2024 and by coming within less than 300 feet of her outside a courthouse in Phoenix. Ms. Owens alleges that by engaging in interstate travel with the intent to violate this court's order, which he did not travel with the intent to violate the order, he traveled with the intent to be a witness where he was subpoenaed. His intent is not what you state it is, and that is a lie, and it's lying. Mr. Maricini both violated the order and committed a criminal violation of the Violence Against Women Act, 18 U.S.C. 2262, based on those allegations. Ms. Owens has asked this court to make the DVRO permanent and to refer Mr. Maricini for potential criminal prosecution. Good luck with that. Ms. Owens' request to renew the DVRO was filed pro se, but included a declaration from undersigned counsel at the time. The undersigned counsel's declaration was solely submitted in his capacity as a witness, not as an attorney representing Ms. Owens. Okay. The declaration explained undersigned counsel previously represented Ms. Owens in a paternity case in Arizona, styled Owen v. Eckerd. The declaration explained during that proceeding, Mr. Maricini was initially disclosed as a potential trial witness, but Mr. Maricini's counsel, Randy Sue Pollock, later indicated in writing that Mr. Maricini would not appear at trial as a witness. Yeah, and that changed. Despite this, shortly before June 10, 2024 trial in Owens v. Eckerd, Mr. Maricini publicly released 2,500 pages of text messages exchanged with Miss Owens while the parties were dating. This was done without a subpoena or a court order and without any formal discovery request in the Owens v. Eckerd litigation. Mr. Maricini simply leaked this private information, which resulted in thousands of his private messages with Miss Owens being posted on the internet, where they remain to this day. Where? You say they exist, but why don't you ever show us or cite to this so that the judge could also go see where these 2,500 pages were leaked? Y'all say that, but y'all don't have any receipts for it. And you like to try to post cites and receipts when you actually have receipts, but most of the time you don't. In addition, the declaration of undersigned counsel explained that on June 10, 2024, Mr. Maricini was observed violating the court's DVRO by coming less than 300 feet away from Ms. Owens in the parking lot outside of Maricopa County Superior Court in Phoenix. This resulted in undersigned counsel contacting law enforcement to request enforcement of the DVRO. You want to attach the police reports and what they told you and your client at that time? No violation? Which I know that they're not the end all be all, the judge would be, but because undersigned counsel was a witness to these events, a preliminary decision was made not to represent Miss Owens in this matter, even though such representation would clearly be permissible under Professional Conduct Rule 3.7A3, expressly allowing a lawyer to act as both a witness and advocate as long as the lawyer has obtained informed written consent from the client. Despite this, after Miss Owens learned that Mr. Maricini retained counsel, Mr. Serrato, she asked the undersigned counsel to represent her on a limited scope basis for the purposes of the Zoom hearing held in this matter on August 15th, 2025. The undersigned appeared briefly at the hearing, but has never filed a notice of appearance in this case and is not Miss Owens' counsel of record. Shortly after the initial hearing, several lengthy discussions occurred between Mr. Serrato and undersigned counsel, David Gingras. This included a phone call on August 18th, 2025, which lasted 66 minutes. During that call, Mr. Serrato tried to convince undersigned counsel not to represent Ms. Owens in this matter for various technical reasons. Following that discussion, undersigned counsel spoke with Ms. Owens about the issues. During the conversation, a decision was made that undersigned counsel would not continue to represent Ms. Owens in this case. The reasons underlining that decision are privileged and protected by Professional Conduct Rule 1.6 and Business and Proof Code 6068. The termination of the representation of Ms. Owens was reported to Mr. Serrato by phone on August 21st, 2025, in a call which lasted 16 minutes. During that second call, undersigned counsel told Mr. Serrato unequivocally that he no longer represented Ms. Owens and that he would not appear as her counsel in any further proceedings. Well, see, you don't have that in an email, and this is the first time you're mentioning in any further proceedings. But, like I said, excuse Omar for not believing you because you like to go back on your word. You move the goalposts. Later that same day, Mr. Serrato sent an email requesting verification of this point. David, do you mind sending a quick email verifying in writing you're not going to represent Laura? Later that same day, undersigned counsel responded to Mr. Serrato via email and stated, yes, this confirms, as we discussed on the phone today, I am not going to represent Laura any further in the Maricini matters in San Francisco. The next day, because it was unclear whether the first message was successfully sent, a second shorter follow-up message was sent, repeating the same thing. As we discussed on the phone yesterday, I no longer represent Laura in the Maricini DVRO matter. Emphasis added. But that just says I no longer represent her. That email does not say and any further, and I will no longer in the future represent her in the Maricini matters. It just says right now you no longer represent her. That doesn't mention in the future. You're saying it in your motion, but that's not what your email said. So, yeah. Mr. Serrato responded to the second message on August 22nd, 2025, confirming he received it. Omar said, thanks, David. Despite knowing undersigned counsel no longer represented Miss Owens in this matter, and despite receiving written confirmation of the fact, on August 22nd, 2025, just 3 days later, on August 25th, Mr. Serrato filed a 15-page motion supported by more than 100 pages of exhibits seeking to disqualify undersigned counsel in this case. In this motion, Mr. Serrato falsely represented to the court that undersigned counsel continued to represent Ms. Owens, a fact Mr. Serrato knew was false at the time it was made. Indeed, Mr. Serrato clearly knew that the entire basis for his motion that undersigned counsel continued to represent Ms. Owens was false. We discussed earlier about how it was said in the motion and how David is misunderstanding, as usual. Based on these facts, the undersigned requests leave of court to intervene in this matter for the limited purpose of seeking sanctions against Mr. Serrato. In addition, the undersigned seeks an award of fees and costs against Mr. Serrato and requests that this court refer Mr. Serrato to the State Bar of California for investigation and discipline. Good luck with that. Discussion. A leave to intervene should be granted. To begin, despite having briefly appeared as Ms. Owens' counsel at a single short hearing, the undersigned is not a party to this matter. As a non-party, the undersigned arguably lacks standing to seek any relief from the court, including sanctions. Provided the courts may not award sanctions to non-parties, and explaining in analogous circumstances, only a party may move for an award of sanctions. For that technical reason, leave to intervene is sought pursuant to CCP 387 for the limited purpose of seeking sanctions against Mr. Serrato. Under that provision, the court may, upon timely application, permit a non-party to intervene in the action of the proceeding if the person has an interest in the matter in litigation or in the success of either party of the parties or an interest against both. You have no interest in this in regards to the parties. Permissive intervention under CCP 387 is appropriate if the proper procedures have been followed. 2, the non-party has a direct and immediate interest in the action. You have no interest in the action in the DVRO renewal. You have a personal agenda and a vendetta. The intervention will not enlarge the issues in litigation, which you've already made a sideshow and are enlarging the case because we now have to have separate hearings to deal with your nonsense. The reason for the intervention outweighs any opposition by the parties presently in the action. It doesn't, like, this doesn't need to be a thing because this has nothing to do with Maricini or Laura, who are the parties in this case. Here, leave to intervene is requested solely for the limited purpose of seeking sanctions against Mr. Serrato based on his outrageous, unlawful, and unethical misconduct. What unlawful conduct? And there is nothing unethical about trying to disqualify an attorney that you don't think should be on the case. He has good faith basis to make that argument that you should not be attached to this case because you are too close to it, which is a conflict of interest. The judge doesn't have to agree, but Omar can ask for it, and it's not a crazy ask. This request will not in any way expand or enlarge the other merited-based issues in the litigation. Indeed, the request for sanctions is entirely unrelated to the merits of this proceeding. It has nothing to do with this proceeding. It has to do with your hurt feelings. This is not the time and place to bring your grievances, and I hope the judge says that. The sole question raised by this motion is whether Mr. Serrato engaged in misconduct sufficient to support the award of sanctions. resolving that simple question will not affect any other aspect of the dispute between Miss Owens and Mr. Maricini. Accordingly, leave to intervene should be granted for this limited purpose, assuming the court agrees relief cannot be granted to a non-party. B. Mr. Serrato's motion to disqualify violated CCP 128.5. As the court is aware, CCP 128.5a provides a trial court may order a party, the party's attorney, or both, to pay the reasonable expenses, including attorney's fees, incurred by another party as a result of actions or tactics made in bad faith that are frivolous or solely intended to cause unnecessary delay. Nothing about this was going to cause unnecessary delay. There is nothing frivolous or anything done in bad faith. It should have been, can we have something by you, judge, that says that this attorney is not going to be on this case? Yes or no? Blown it up. For the reasons explained above, Mr. Serrato's motion to disqualify was objectively frivolous and made in bad faith. Nope. At the time the motion was filed, Mr. Serrato knew that the attorney-client relationship between the undersigned and Miss Owens had ended, and that the undersigned avowed that he would not appear any further in this matter as Owens' counsel. That's not in any of the emails. And it doesn't sound... I don't know if you said it on the phone in your ramblings. Maybe you meant it, but nothing is stated, and there are no black and white receipts that says that you were not going to any further or any in the future. As Ms. Golden, knowing this, there was no legitimate reason for Mr. Serrato to ask the court to disqualify Miss Owens' counsel, who is no longer her counsel. Yeah, to cover his ass and to zealously advocate for his client. That's not done in bad faith. Nevertheless, Mr. Serrato falsely represented to this court that the attorney-client relationship was contentious and ongoing. Arguing relief was required to eliminate a clear conflict of interest, a conflict which Mr. Serrato knew did not exist. Yes, it does. The sole basis for the alleged conflict was the concurrent role of the undersigned counsel as both Miss Owens' counsel and as a witness, but Mr. Serrato knew no such conflict existed because he knew the undersigned counsel no longer represented Miss Owens at the time the disqualification motion was filed. Mr. Serrato simply lied about this fact to the court for the purpose of creating a false, non-existent basis for him to file a disqualification motion that falsely accused the undersigned counsel of professional misconduct. Yeah. Nobody is falsely accusing you of shit. Let's read what the snippet says, okay? Conclusion. For the reasons Respondent Mike Maricini respectfully asked the court to disqualify David Gingras, Esquire, from representing petitioner Laura Owens in this DVRO renewal. Disqualification is necessary to eliminate a clear conflict of interest, enforce the advocate witness rule, and preserve the fairness of the proceedings. No lies told there. If needed, the court may briefly continue the hearing to allow petitioner to retain new counsel, ensuring the matter is resolved on the merits without ethical compromise. Yeah. There shouldn't be ethical compromise. You should not be representing her. By removing Mr. Gingras, the court affirms that the justice may not be clouded by an attorney, conflicts, or dual roles, thereby safeguarding both parties' rights and the integrity of the tribunal. Where is the dishonesty? that you say exists? Where are accusations of professional misconduct? He is saying before before anything happens that might be considered professional misconduct or a conflict of interest, can we please have this ruling, Judge? And it never hurts to ask. The court should never accept intentional dishonesty from any lawyer appearing before it. Okay. As officers of the court, attorneys may never engage in deliberate dishonesty towards the tribunal. Because Mr. Serrato broke the most inviolable rule, the court must impose significant consequences to deter any future misconduct. I would like to know if a judge is going to see it your way. I don't see it going that way. Now let's get to the reason that he thinks that the safe harbor provision of CCP 128.5 does not apply. Because he's all about the safe harbors. He says when a party or a lawyer violates CCP 128.5, this does not always support an automatic award of sanctions. Rather, like it's a federal civil counterpart, contains a safe harbor. In most cases, this safe harbor precludes any award of sanctions unless the violator, Mr. Serrato, is served with a draft motion for sanctions and an opportunity to fix the violation within 21 days. That has not occurred here, but this is no barrier to sanctions. This is so because the safe harbor provisions does not apply in a case where the violation causes harm which could not be cured by withdrawing the offending pleading or tactic. Specifically, the rule is clear. The safe harbor only applies if the alleged action or tactic is making of a written motion that can be withdrawn or appropriately corrected. What needs to be corrected? Nothing. And if you wanted Omar to withdraw this, which you don't want him to withdraw this, or you would have just said, hey, can you withdraw this motion? And I will just, put in a declaration to the court that I do not intend to represent Laura Owens at any point further in this case. And that be it. But no, you've got to blow this up into some huge big thing where you're blabbing about a bunch of shit that does not make sense and is not based in reality. There is nothing that Omar said that is incurable against you. For instance, in the marriage of somebody, the Court of Appeals affirmed an award of sanctions despite the fact that the violator was not given any chance to correct the violation within the safe harbor period. This result was based on the fact that the violation arose from a false statement made by counsel to the court. Yeah, I wonder what that thing says. The Court of Appeal held the harm caused by the lawyer's false statement had already occurred and was incurable. Thus, the safe harbor did not apply, given the nature of the conduct on which the sanctions were based. Trigger's misrepresentation to the court that she was ready to proceed to trial when she was in fact not ready, her failure to ever correct the court's misapprehensions as to her readiness, and her delay in seeking continuance until after the case was called for trial. The safe harbor provisions are not applicable. Well, that's not anywhere near what happened here. Because that can't be cured. If an attorney says that somebody is ready to go to trial and they are actually not ready to go to trial, and the judge is like, too bad, we're going to trial because you said you were ready. And then they say, no, I don't know why my attorney would say that because that is not true. That's when there is a knowingly lie that does not give her case like it cannot be fairly adjudicated if it's if it's rushed. Nothing that Omar said here prejudice Laura in her case. Nothing. There's no reason to be doing this. You are reaching so far into your ass to pull this shit out. I don't see how you don't have a headache from going that far into your ass. Because what the hell? None of your sites are comparable to this case. And what is happening? You really do live in a delusional, false reality. Similarly, in another case, the court affirmed an award of sanctions under the analogous provisions of CCP 128.7 without applying for safe harbor period. In Shinnefield, an attorney was accused of violating Family Code 3111 by publicly releasing information contained in a court order, psychological evaluation. Based on that misconduct, the trial court sanctioned the lawyer under CCP 128.7, even though the lawyer was not provided a safe harbor opportunity to correct the violation. Well, yeah, because that can't be fixed by withdrawing it, because somebody's medical and mental information is out there. And so by pulling it back, it's still out there. Nothing Omar said was harmful to you. Like, these are drastic things that happened. I can see why there was sanctions in these other cases. The Sheffield court held the 21-day safe harbor period of CCP 128.7c1 did not apply because the lawyer's conduct caused harm which could not be corrected. Yeah, as they should have. In other words, because the harm, disclosure of confidential record, already occurred, there was no point providing a safe harbor for the lawyers to correct the misconduct. On that issue, the court explained, we note too that a safe harbor provision would not be appropriate here because the harm Family Code Section 3111 seeks to prevent is not the reduction of meritless litigation, which the Code of Civil Procedure Section 128.7 seeks to avoid. Providing an attorney with the opportunity to retract a statement within predetermined time does not avoid the harm of disclosure. There was no harm done to you, David. The same logic applies here. To be sure, Mr. Serrato violated both CCP 128.5 and 128.7 by filing a pleading that contained false and frivolous statements in bad faith and for improper purposes. No, that's not what happened. But Mr. Serrato's misconduct is not limited to only a filing frivolous pleadings, and the harm he caused will not be eliminated by allowing him to withdraw the motion to disqualify. That motion was moot before it was filed. This is so because Mr. Serrato's misconduct also includes making threats of violence against Ms. Owens and undersigned, and filing frivolous pleadings containing false and defamatory statements attacking the undersigned, which he knew would be turned into lengthy YouTube videos by his friends, which is exactly what happened. Mr. Serrato's scheme intentionally caused the permanent online distribution of the false statements in the motion to disqualify. Yeah, because you don't like what somebody wrote, you copyright strike them. Which wasn't even the person who wrote the things. She was just reading a writing. This misconduct and the resulting damage is impossible to remedy through a safe harbor correction. The thing is that what you're constituting as threats of violence did not happen in the span of this case, of this renewal. So you think that you are trying to tell the court that he's been making threats of violence to you and your client That has not happened since he's been the attorney on this case. And one, it's never happened. There's been no threats of violence to you or Laura. But continue spinning your lies because that is a lie. You say you don't lie, nobody can call you out on a lie. You saying that you and your client have been threatened by us YouTubers is a flat out lie. This is so because this court cannot order third-party websites like YouTube to remove content even when the material is entirely false. Explaining federal law precludes California state courts from ordering the removal of online content. In this way, the case is closely analogous to Sheffield. The damage caused by Mr. Serrato's misconduct has already occurred. The harm is irreparable. It cannot be cured by after-the-fact withdrawal of this motion, since this would have no impact on the lies that have already been republished and spread in other venues, including YouTube. Because the misconduct and the damage it caused cannot be cured by allowing Mr. Serrato to withdraw his motion, the safe harbor provision does not apply. Sir, you still have not said what harm this has even caused you. That is so incurable. You have not explained how you were harmed. There's been no irreparable harm done to you. You would not win in court over this. Even if you filed a civil lawsuit, you wouldn't receive any money because it's bullshit. Disciplinary referral to the state bar is appropriate. In addition to imposing economic sanctions on Mr. Serrato, this court should go further. This court should also make factual finding that Mr. Serrato has engaged in intentional dishonesty by filing a pleading which he knew contained false statements. The court should separately conclude that Mr. Serrato's bizarre and threatening online posts and attacks against Ms. Owens constitutes a separate basis for discipline. He did that when he was not an attorney on a case against her. And they still were not threatening online posts or attacks. So disingenuous. Mr. Serrato's actions in this case closely mirror the results in a recent disbarment of a Florida lawyer. That happened in 2025, March. In that case, like here, the lawyer posted a series of threatening online messages attacking opposing party and counsel. Among other things, the lawyer posted a picture of a Tommy gun being fired by a movie character from The Mask and the message, "Me, the next time I'm in front of the Liverpool back line. You guys suck." Based on that conduct, among other things, the Florida Supreme Court ordered the attorney to be disbarred. No, nobody has done that here. The only person that's brought up gun violence is you in your videos. Here, essentially, in the light of recent events such as public execution of conservative commentator Charlie Kirk in Utah, threats of violence, even if made jokingly, are completely and totally unacceptable. Except for Omar hasn't made any of these comments. Mr. Serrato's threats to bring the Gunsmoke made to both Miss Owens, the undersigned, may appear funny to him, but they are absolutely no joking matter, especially when Mr. Serrato was not only extending threatening words, he also took the time to create a childish image that shows him with bulging muscular arms holding the undersigned in a chokehold. Ha ha ha. Really? You want to put ha 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 in your motions to the court? God, you're such a fucking liar. Mr. Serrato's conduct is not funny. It is illegal. It is unprofessional. And it is woefully inappropriate for any officer of this court under any circumstances. That is doubly true given the context of this case, involving a domestic violence restraining order. This had nothing to do with a domestic violence restraining order. You are putting things in here out of context, knowingly. That is doubly true given the context of this case involving just even worse, it appears to reflect a pattern of misconduct, as this was not the first time Mr. Serrato has been accused of lying in court. And then he cites a case discussing allegation that defendant and her counsel, Mr. Serrato, have intentionally made false statements in support of their motion. Okay, people can accuse people of making false statements all the time. That doesn't mean that they actually did, especially in family court. How about the false accusation that Laura Owens made about Greg Woodnick? What about those false statements and allegations against a lawyer? Conclusion. For the foregoing reasons, intervener respectfully requests the court grant the relief requested above. September 12, 2025, David Gingras, intervener. Proof of service. He did it through United States mail. I don't know why he decided to do it mail. I enclose the documents in a sealed envelope or package addressed to the persons at the address listed above and place the envelope for collection and mailing. Following our ordinary business practices, I'm readily familiar with this business's practice for collecting and processing correspondence for mailing on the same day that correspondence is placed for collection and mailing. It is deposited in the ordinary course of business with the United States Postal Service in a sealed envelope with postage fully prepaid. I am resident or employed in the county where the mailing occurred. The envelope or package was placed in the mail at Phoenix, Arizona. Why didn't you just email it through electronic transmission? Like, well, you had to mail it, snail mail it? Okay. And he signs under the penalty of perjury. Well, that's interesting because you perjured yourself, in my opinion. And he served it on Laura Owens, who is pro se, and Omar, attorney for respondent Michael Maricini. And let's end this video with a description of the person who wrote this motion, the intervener himself, David Gingras. His character trait is disingenuous. Disingenuous is a character trait that refers to someone who is insincere or deceptive in their behavior or speech. It describes a person who pretends to be honest or sincere, but actually has hidden motives or ulterior motives. Yeah. And he projects those hidden motives and ulterior motives onto other people because he thinks people behave the way he behaves. And it's just not the majority. A disingenuous person may use flattery or false praise to manipulate others, or they may conceal their true feelings or intentions behind a facade of politeness. Essentially, a disingenuous person is someone who cannot be trusted to be truthful or straightforward, which is by definition David Gingras as a lawyer. Which is why Omar felt the need to file to have him disqualified off of this case, because he is so disingenuous. And to me, he has brought fraud upon this court in this motion and in his declaration. He is a fraud and unethical lawyer. Like this video, comment down below what your thoughts are. Subscribe, turn those notification bells on so that you continue to get notified when I upload new videos. Bye.